Welcome, friends. We are going to let folks make their way in from the waiting room, and we will get started in just a moment. All right. Well, welcome, everyone. Thank you to all of you joining us live for today's program, Healing to Wellness Court, Tradition, Justice, and Recovery in the Penobscot Nation. And thank you to everyone who is watching this recording on YouTube. We are delighted to welcome Magistrate Judge Rhonda Decontie and Chief Judge Eric Mehnert today. Judge Decontie is both the clerk of the courts and cultural advisor for the Healing to Wellness Court. She's made history as the first magistrate judge of the Penobscot Nation Tribal Court and later as the first magistrate judge for the Holton Band of Maliseet Indians. Her contributions throughout her career have been nationally recognized, and she's received awards for her leadership and advocacy for wellness courts, and it is a real honor to have her with us today. Judge Mehnert has served as Chief Judge of the Penobscot Nation Tribal Court since 2008 and was one of the authors of One Nation Under Fraud, alongside former Penobscot Nation Tribal Representative Donna Loring. He previously served as Chief of Enforcement of the Commonwealth of Massachusetts Commission Against Discrimination, overseeing a staff of 15 attorneys and 45 investigators prosecuting discrimination cases in Massachusetts. It is an honor to have you both with us today. My name is Kathleen Neal. I'm the Senior Director of Policy and Partnerships here at Maine Conservation Voters and Maine Conservation Alliance. Our organizations represent more than 13,000 members and supporters dedicated to building a just, thriving future for all by acting on the climate crisis, protecting the environment, and safeguarding our democracy. MCA does that by bringing people and organizations together to educate, inspire, and advocate, and MCV by advocating for equitable policies, holding elected officials accountable, and winning elections. Since 2020, this weekly online Lunch and Learn series has helped us advance all of those goals, creating a shared space to explore our environmental and social history, policy priorities, climate action movement, and more. It has been one of the great joys of my life and my favorite part of the week every week to get together with all of you for this learning. A few notes before we dive in today. We will hear from our speakers first, and then we'll tackle questions in a Q&A session following the presentation. You don't have to wait, though. You can send questions to me or to Maggie Summers through the chat whenever they occur to you. We'll compile them, synthesize them, and ask as many as possible following the presentation. If you have any technical difficulties, Maggie is the one to help you out. Just send her a message through the chat and she will work her magic. This event is being recorded and the video will be posted on our website later this afternoon. You can also find recordings of all of our programs on YouTube, where there are a bunch of different playlists to help you focus in on particular topics. Finally, I want to acknowledge that we are all here in the homeland of the Wabanaki people. I am zooming in from Camden on the shores of Penobscot Bay, where the Penobscot and Abenaki people have lived for generations. The Healing to Wellness Court that we'll learn about together today is a powerful reminder of the richness of Indigenous wisdom and just how much we have to learn if we can just get out of the way. So with that, I will get out of the way and turn it over to the two of you. Thank you so much.
Thank you, Kathleen, Maggie, and thank all of you, the Maine Conservation Alliance and Maine Conservation Voters, for inviting us here. When I first came to the Penobscot Nation, I had been doing a lot of civil rights work, and I had a lot of federal court work, knew the federal rules of evidence, knew the federal rules of procedure really well. And the chief brought me in the council chambers and said, well, congratulations, we've decided that we're going to appoint you as the chief judge. And I thought, oh, great, they appointed me because I knew all of that. He rapidly disabused me of that notion and said to me, so we've seen how the Anglo court works. $350 fine, next, $350 fine, next. That doesn't work for us at the Penobscot Nation. I said, okay. What are you looking for, Chief? And he said, well, we'd like a problem-solving court. Looked at him and I said, exactly what do you mean by a problem-solving court, Chief? And he looked at me, kind of cocked an eyebrow and said, figure out the problem and solve it. And that was really the genesis of the work that we got to do with the wellness court. Wellness courts are akin to drug courts. Drug courts were originally established back in 1988 by Janet Reno down in Miami-Dade. And then conceptually, their idea was that you don't change behavior by punishing people. You don't change people's challenges with substance use, which is an illness, by punishing them. There are different ways of changing behavior. And so at Penobscot, we began with a wellness court, which is an indigenous approach. Now, I'm not native. We count on, we have 2 cultural advisors at the Penobscot Nation. And Rhonda, Judge Decontie, not only sits as a cultural advisor, she will sit as a wellness judge when alternating with myself. But we work on 4 foundational tenets. The first foundational tenet is criminal behavior. The criminal behavior which brings someone into court, or the behavior which brings someone into court, isn't the problem. The substance abuse underlying that behavior isn't the problem. The problem is unresolved trauma, personal, historical, or both. And we need to get to that. The second is you never change behavior with negative reinforcement, only with positive reinforcement. B.F. Skinner taught us that in 1954. And yet, according to the latest statistics from the Bureau of Justice Assistance, we still continue to try and incarcerate people to change their behavior. I think 76.9% of the individuals who are incarcerated with a substance use disorder and are untreated during their period of incarceration are back in prison in 3 years after being released. That is a horrific number. The idea that we continue to do that, I tell people, my parents were both psychologists, and one of the things, when people say that explains a lot about me. I've had every test you can take twice. But one of the things that they did teach me was that the definition of insanity, which is doing the same thing over and over again and expecting a different result. We continue to incarcerate people and say, oh, well, we hope they'll get better and when they come out. That's a fallacy. It's never going to work. And what's really shocking is when you look at the statistics that tell us on the success rates for wellness courts and drug courts, it is if an individual successfully completes the program, and not everybody does, but if an individual successfully completes the program, 67% of those people do not end up back in jail. And that is, to me, a startling statistic when you're talking about our criminal justice system as it sits in the current configuration. The third area that we talk about, and third foundational tenet, is you never change behavior with compliance. It's commitment, not compliance. We can't compel somebody to get well. They have to be committed to their change. And if they are, they will be successful. And fourth is alienation drives addiction. And what we mean by that is what often happens in the community is if an individual is using substances, first the community members say, stay away from them. They're a druggie, stay away. And then the next thing is they go to their friends and their friends are like, nah, you can't come here anymore. You can't stay here. And finally, they alienate their own family, which says, look, we're not going to deal anymore. that cycle of alienation is a downward spiral that leads to more self-medication along the way. And I think one of the things that we've learned over the course of time, the work that we've done, is really that community is the opposite of addiction. That if we can build a community, and in fact, the data that we have, particularly for tribal members, is that the number one protective factor for Native Americans in recovery is culture and community. It is, if we can assist an individual in getting re-established with the community and re-established with their culture, we know that that's going to be the number one protective factor in their recovery. So if we can go to the next slide. At Penobscot, the Healing to Wellness Court is a braided service approach. Judge Decontie, you want to talk a little bit about that, that braided services approach?
For sure. So when an individual comes in, they are, I guess, a lot of different departments have interaction with them. So when we first started, our team was very small. And as we grew and expanded, well, the next slide will show our team members, but having all of these different services coming to the court to discuss case plans and how our wellness relatives are doing were really important and very needed. They say it takes a village to raise a child. It's going to take a village to heal a person, especially with this illness that they have. So by growing our team to, include all the systems that they're using was really crucial in the development of their growth and their wellness. So we are very fortunate at Penobscot. We have a lot of different services that are offered, and we have great people from those departments. If you want to go to the next slide, that there we go, that are part of that. On this slide, it has, of course, our chief judge, our public defender and prosecutor, and then one of our case managers. But a new role that we developed, the young woman on the top, her name is Kylie. Kylie is a recent graduate of the program, and we really thought about it for a few years. How could we do this? How could we integrate a person that has gone through the program into our team? And she was the perfect fit. She brings a point of view that we don't have. She enlightens us of our strengths and weaknesses, and how we can grow and continue to, develop this. Because I like to say we're always growing, we're always developing. We're not just staying at, how we used to do it or what have you. There's changes, updates that we need to stay current, with best practices. So if you want to go to the next slide, these are other team members, and having social services, education. We have an elder on our team as well, outside case management, and of course, medically assisted treatment are very crucial to us. Next slide. And then we have our behavioral health. We have the program coordinator for the Noalasi. She does a lot of outreach with folks that are in recovery, and social services again.
So if I can jump in real quick, the way the program works, the Healing to Wellness Court works, as I said, it's modeled on all of the 10 key components, and we can talk about those later, of the National Association of Drug Court Professionals. But essentially, all of them work on a 4-phase program. And the NADCP labels with phase 1, phase 2, phase 3, and phase 4. Those are each program, each phase is 90 to 120 days long. In the initial phase, the individual will be tested 3 times a week, randomly tested 3 times a week. They will be required to meet with their case manager 3 times a week. They're required to go to NAAA or Wellbriety, which is a Native American recovery group, 3 times a week. They're required to meet with a clinician once a week, or as a clinician suggests. As they move through the program, the intensiveness of those meetings will start to tail off, so that by the time they're in the final phase of the program, they're meeting with their case manager once every other week, and they're coming into the wellness court every other week. With these braided team approach, we meet as a multidisciplinary team every other Wednesday. And at every other Wednesday, you'll hear that the case manager comes in, case managers, and we have 2, come in, and they have given us a written report of the individual's strengths and challenges. And then what we'll look at is, okay, as a team, what can we help this individual with? Sometimes we'll have questions about, and this is always a big one, housing is a huge, huge issue in recovery. And so there'll be questions about how do we help this individual with housing? That can be on site with tribal housing in the reserve, or as you heard Judge Decontie talk about, with the outside Wabanaki Health and Wellness. But what we're doing is having a conversation. In Wabanaki Health and Wellness, we may go, look, this individual doesn't meet the requirements for the tribal housing, but WAB will step up and go, well, maybe we can help them fill out the form for Section 8 housing. So we'll coordinate services. What had happened long ago in the state system or in the federal system, and even early on when I was here, was there was siloed. There were siloed systems. And social services did their thing, and the court did its thing, and behavioral health did its thing. The challenge with that is that the things that bring people to court, the challenges that bring people to court, are not strictly legal in nature. They are legal, sociological, and psychological. And unless we can combine our approach to resolving those issues, we're not going to make a difference. And that has really been the strength of the braided services approach. What's been really interesting about that is how it has carried over in all of the work that we do in the tribal court. The tribal court is a court of general jurisdiction. It handles everything from criminal matters, C-class felonies, all the way through probate matters. We see child protective, we see cases involving custody and parental rights and responsibilities. But the approach here is to how do we solve that problem and what services can we bring to bear? And the wellness court has really been a focal point of showing us how we can work in a multidisciplinary approach to resolve issues in the system. I'll bounce it back to you, Judge Decontie, on the outcomes here, the goals.
Yeah, so I think I kind of want to go a little ahead about how we made this program more culturally engaged for our folks. And I started in 2011. I was approached that a job was opening up at the court, and my first reaction was, why would I want to work at a court? Nobody wants to go there. And when I came here, I was able to hear about the problem-solving approach as well as healing to wellness. And I thought, okay, I can use my traditional values and morals and incorporate that into a system that lacked them. And so how do I weave that together? I've been training for this since I've been a young person, and watching my dad walk through recovery and then also weave different ceremonies and practices with that and help other people in other communities. So as a young person, I got that firsthand experience of how you do that, and then was able to apply it to a place I never thought I could, which was a court. So the first thing that I saw was when we would have our sessions, we were set up like any other court. And if you've been into a court, you know that the judge sits at one end and there's two tables, and that's how you interact with the court. As a clerk, I would sit in the corner, record everything that was happening, and we would have a few people in the back, which were our counselors, and I would see folks stand up, have respect for the court, and then try to kind of acknowledge the people in the back of the courthouse while they were giving them praise. And I thought, geez, this really isn't okay. It seems very awkward. And so I asked, can we make a change? I was very fortunate to have a judge that was willing and accommodating to say, yeah, let's do it. So the first thing that we did was remove the tables. Sitting in a semicircle is more practical for us, and being able to see each other, because at the end of the day, we had to remember why we're here, and that's for healing. Um, Sitting like that is very, it almost feels, how do you say that? Like confrontational, as opposed to when you're in a circle. So we started with that. And then a few sessions went by, and I was like, you know, it would really be nice if we could kind of set the tone for this hearing. Why are we here? We're here for healing. So can we start with a smudge and a prayer? Sure, let's do it. Couple times we did set off the fire alarms, and everybody had to evacuate the tribal administration building, but we worked that out. The third thing was, like Judge Mehnert has said, we have 4 phases, and I would be sitting in the corner, and somebody would advance to phase 3. Okay, what does that mean? So at the time I was able to sit down with the case manager, who was my sister, and we talked about, we have 4 phases, we have 4 medicines, how can we make the medicines work for the phase? And we did that. So our first phase is tobacco. We moved to cedar, to sage, and then to sweetgrass. When folks do advance to that phase, they're given that medicine. Then we started incorporating cultural engagement. We would ask them to participate in a cultural event. If there wasn't something hosted in the community, we would host it ourselves. One of the activities that we did was a dream catcher vision board. And we had them come in. We took a big piece of paper. We drew out a dream catcher, and in the feathers that hang from that was their main goals. And the web part was, what do I need to do to accomplish that? So I'm very visual. I know a lot of people like to have something, you know, on the board that you can kind of check off. This is what I've done. You can color it in. We had them come back to court, you know, weeks later, bring your vision board in. Where have you gotten so far? Gathering sweetgrass. That is one of my most favorite things to do. We do that the end of July and in August. Somebody asked me, what does gathering sweetgrass have to do with healing to wellness? And I stopped and I paused, and I'm like, this is one of our practices that we're reclaiming. And when we do that, we are identifying ourselves in that capacity. And part of you know, sweetgrass is used, it's one of our medicines, it's used in basket making and other things. And I think by reclaiming that, you're regaining self-esteem, you're regaining confidence. And I said, it's got a lot to do with healing to wellness. So the conversation kind of quickly changed with that. Regalia. A lot of our folks are disconnected from the community, they're disconnected from their culture. How could I use my skills to re-engage that? Before I came to the court, I did a intergenerational sewing project. And so I said, okay, I can sew. We're going to do that. So we've done shawls, we've done ribbon skirts, we've done ribbon shirts. I've taught all folks how to sew. It's a great skill. And they get to wear that at their commencement ceremony. Basket making. We had folks come in, teach us how to make baskets, from very small ash to then birch. Drum making, that's another thing that we've done. We've had folks come in, they're able to dye them if they wanted to, paint them afterwards. But really, you know, that drum is the heartbeat. So we wanted to include that as well. When we moved to our new location, we're right along the river and we're in our own space. So I thought, how wonderful would it be to create and build a sweat lodge, our own healing lodge. We did that.
And the name.
Yes. So we named it Debayuan Lodge. Debayuan means truth. And I think that's all goes into what we're looking for, the truth of ourselves, you know, in our healing, truthful with others. And so those ceremonies are done kind of as needed throughout the year. We do hold them in the winter as well. And then as we were starting to grow, I thought, okay, we're giving a lot of things to the or relative. Let's start incorporating at the end of before they commence a give back project, because I think it's a core value of not only receiving all of this, but also giving back. We've had a lot of creative ideas for give backs, a lot of volunteer work. I had one participant or relative, sorry, join me and my sisters, and I was working on a project of cleaning an elder's yard. And I told her about the group that we started. It's called Three Sisters, and what we were hoping to do. And she came, worked with me for an afternoon and cleaning, raking, mowing, and she was very proud of that. I appreciated the help. It was a big task. We've had folks give lunches to unhoused people in Bangor. We've had people donate at the food pantry. We've had gifts made. We have a nice feather fan that one of them made, paintings. So anything that they can contribute to the community, to the court, is well appreciated. And then lastly, for our commencement ceremonies, I remember the first time we had somebody graduate and we didn't know what we were doing. They completed the program, they came in, the public defender and the prosecutor were there, I was there, the judge was there, and we had a conversation. He collected some artifacts on the river. He brought them in, he showed them, we had a conversation, and that was it. And I thought, wow, you know, this is a really intense program that he just completed. It's long. There's a lot of other people involved. Can we have food? Can we incorporate having the big drum? Can we incorporate their family? Can we incorporate their friends? So our commencement ceremonies now are very robust. we have all of those things included. We have a blanket ceremony, we have a challenge coin. They re-get all of those medicines, and it's a big celebration.
Oh, so as you can see, Judge Decontie is really responsible for the growth and development of the Healing to Wellness Court. She did some amazing work and continues to do amazing work in the court. A couple of other things about the court. When we talk about Wellness Court, the date that we hold court, so we hold the Wellness Team meeting every Wednesday, every other Wednesday, and then the Friday immediately thereafter, we do the Wellness Court. At the Wellness Team meeting, what we're doing is discussing what the individuals got going, what the good things are going, the challenges they're facing. And we have to make determinations. Okay, are they eligible for an incentive, or do we need to do some kind of sanction? Now, one of the things that as we talked about earlier, is we know that we only change behavior with positive reinforcement, not negative reinforcement. But we do believe we have to hold individuals accountable. And that's part of the role of the court. We often talk about it in terms of what are the guardrails. And we said when someone first comes into the program, we narrow the guardrails are very, very narrow. And if someone bounces up against it, we respond. And at that point in time, we call it, it's really a behavioralist, from a psychological point of view, a behavioralist approach. It's stimuli response, stimuli response. As an individual moves through the program, guardrails open up significantly wider, and we hope that the individual switch from a behavioral, I'm going to do this because I don't want to be sanctioned, to I'm doing this because I know it's the right thing for me. And that has been the way that it's worked. But at those team meetings, we'll have discussions about, okay, this is where the individual is, what do we need to do in response to that? Then on the Friday, we hold wellness court. All of the team members are invited. And as Judge Decontie indicated, all of the participants sit there. I think one of the things that she forgot to mention is we used to just have the judge would do the colloquy with the individual, and then the public defender would speak, the prosecutor would speak, and maybe a provider or two. And she came to me and she said, Judge, is there any reason why only you and a few others get to speak? You know, I don't know. No, I don't think so. And she said, well, in this community, everyone gets a chance to speak. So now when we sit in that semicircle, we'll go around and all of the participants will speak. And they will offer their thoughts and offer words of encouragement. It takes a little bit longer to do it that way, but one of the things that we have found has been that the participants often have some of the greatest advice for other participants because they've lived through the experience, and there is a commonality that they have. One of the other things that we found that's made the wellness court really successful is peer norming. That as the peers start to look at each other and they go, oh, everyone's doing this, so this is my community, this is what I'm going to do in this community. And we find that that really makes it so there are very few sanctions that we have to impose. If we have to impose a sanction, the sanctions run all the way from, listen, you saw this coming, we saw this coming. What we need you to do is write an essay on what you saw, so that you'll recognize what your triggers are with regards to that. And what are you going to do next time to protect yourself? And then when you come in the next time into wellness court, we're going to have you read that essay. If behaviors continue, and we talk about it in terms of proximal and distal goals, proximal goals are those goals that they can do. Distal goals are those goals that we hope that they'll gain the ability to do later on. But the proximal goals, we know they can do. If it's a proximal goal that they are not doing and continually not doing, then we have to continue that response and holding them accountable. Now, there are certain things that we know. So, for instance, we don't expect when someone comes in that all of a sudden they're going to be substance free the next day. That's not a reasonable expectation. So what we talk about is we expect someone comes in and says, oh, look, I've got they're a polysubstance user. We'll say, this week you knock out meth. Well, actually, what we typically do is the first one you knock out is fentanyl. You got to knock that out. That's life-threatening, and we want that gone. Next time we come in and you got testing, you got to knock out another substance, and we'll continue to knock out the substances through that tobacco phase. If in fact that, and most of the time when we say to an individual, we know that you that you violated the policies and procedures of the wellness program, they go, yeah, I know I did, and we have that. That's fine. We can move forward. But we do provide a public defender, and we do have a prosecutor. And so the prosecutor will make the motion for sanctions, and the public defender will meet with their client. And if their client the participant wishes to contest it, we will actually hold a due process hearing at that point in time on the issue of whether or not they should be sanctioned and what is an appropriate sanction. So they still have their court protected rights in this. We try really hard to work on a consensus model as far as what are we going to do and how are we going to do it. The model calls for you can use jail as far as the model. We have not done so in years. We have found it to be much more effective. And I will freely admit, I used jail when I first started in the program. I thought, oh, well, if they don't do it, I got to take action as a judge. I gotta set a firm boundary. But as we've developed those foundational tenets over time, we've come to the conclusion that jail really isn't an effective sanction. And what has become the most effective sanction that we've used is if we get to a point where an individual is repeatedly not being accountable to the wellness policies and procedures, we will say to that individual, okay, here's your choice. You can either be terminated from this program, or you can go, if it's warranted, and it usually is, back to inpatient treatment. And if you go to inpatient treatment, we'll suspend that termination until you complete the inpatient treatment and come back out. Most of the time, the individuals go, I'll go back to the inpatient treatment. And that's something that's really important. Those providers that we work with for inpatient treatment, if we can get someone to do inpatient treatment for 90 days, we'll take 30, but if we can get them into 90, there is almost a guaranteed success in the wellness program because they have established that foundation in inpatient, and then we're working to reinforce that as they come back out. While they're in inpatient, we will continue to have them in the wellness board. So we Zoom people in from wherever they are, if they are inpatient. And we'll bring them into the program to participate so that they continue to build that community of peers. When we look at that, the program has been so successful that one of the places that we now see that we get individuals from is because of the Settlement Act and the way the Settlement Act is, well, it's weird. It's not how it works. I do contract work for the Bureau of Indian Affairs throughout the country, and the Maine Settlement Act is unique. It doesn't recognize full tribal sovereignty, but the reality is that with the way the Settlement Act works is that if a tribal member commits a felony, they will go into the state court system. Typically, in most treaty states, that's a federal court, and then the feds and the tribes work together and have established a working relationship. We're very, very fortunate that we've, and again, Judge Decontie was really the one who took the lead on this, established a fantastic working relationship with other court clerks and judges throughout the state. So now, if a tribal member commits an offense down in Kennebec County or in Cumberland County, and they have a substance use disorder, the judges there will consider, and have actually done this on a couple of occasions, either a deferred disposition where they say as part of a deferred disposition, what deferred disposition is You plead guilty, but I'm not going to enter a sentence on that. And if you actually complete the program, complete what you're supposed to do, then you can uh, recall your guilty plea, and I will dismiss the case. Or probation, a term and condition of probation. This is what the sentence is, and a term and condition of your probation is that you go to the Penobscot Nation Healing to Wellness Board. And so we will take individuals in from the state court system into the Penobscot Nation Healing to Wellness Board. And we've done it from Kennebec County, we've done it from Cumberland County, we've done it a lot from Penobscot County. And here are the admission requirements. Originally, when we first started, we took in only tribal citizens. That has expanded now to descendants and non-native spouses or intimate partners. They have to be clinically assessed with a substance use disorder. They have to be physically and mentally capable of completing the requirements. And they have to be willing and able to consent to the program. The one that you see here, that is one that was put upon us by the grants, and that's an issue that the nation faces. That is that they can't currently be charged as a violent offender, and that is because the Bureau of Indian Affairs does not fund the tribal courts at 100%. They'll tell you they don't of need. So what the court has to do is go and search for grants. We get a grant from the Substance Abuse Mental Health Services Administration, federal government. And one of the conditions of that grant is that we cannot accept individuals who are currently charged as a violent offender. They have it's a definition, and we just picked up that definition from federal law that says this is what the definition of the violent offender is. We try and take in almost everybody who applies. Am I missing anything, Judge Decontie?
No.
All right. So,
And let me know which correct slide I should be on.
now you have done a phenomenal job because I jump all around. Judge Decontie was telling me that at the beginning.
Yeah.
And I think you've covered just about most of everything that we talked about. We talked about the 4 phases. If there are questions out there, we're happy to start talking about those and integrate those into the conversation.
There are questions and a huge amount of admiration and appreciation for the work that happens in the Healing to Wellness Court and for you sharing it with us today. So before we get into the questions, I'll just take a second to remind everyone that you will get an email later this afternoon with a link to the recording of this program. Share it far and wide. I am already thinking about all the people I'm going to forward it to when it comes through. And also in that email will be a couple of opportunities for you to continue engaging with this information and to continue the learning that we're doing today. So first up is next week, gosh, Monday and Tuesday of next week, there's a 2-day conference.
Tuesday and Wednesday.
Oh, Tuesday, Wednesday, thank you. On the Good Path, this event is open to the public. Everyone's encouraged to attend. You'll see a link in the email to the conference registration information. We also really encourage you to listen to the stories of those who have journeyed through recovery and can share their experience with the Healing to Wellness Court. You can read Gabe Stewart's interview with Vice News. We'll have a link to that. There's an episode of Voices to Hope called The Rugged Road to Recovery. You'll find a link to that. And really just reiterating that the more people who know about this incredible work, the more people will apply to take part, who will learn lessons that they can then take and share in their lives. So please share all of this. And then the final sort of call to action is, if you know a tribal citizen who is serving time in the justice system, reach out to the Healing to Wellness Court to talk about getting that time deferred, to talk about getting them into a much more holistic and inspiring and productive process that we've heard about today. Thank you, Judge Decontie and Judge Mehnert, for the work that you're doing and for sharing it with us today. You probably said this, but do you have what's the running total? How many people have been part of this journey so far?
Oh, good Lord, we've been doing it now for, well, since you came on board, Judge Decontie, in 2011?
Yep.
So I can't tell you the numbers, but it has been our census right now. Well, actually, we've just lost 3 to commencement. They have commenced from the program. So the census right now is 7. We've got room. We try and keep it to the same ratio as what we understand clinician for active cases. So our case managers are 1 to 12. We don't like to go above 12, especially in the early phase of the tobacco phase of the program, because it is so intensive. There's so much going on with that recovery. One of the real things that we find is it is imperative that the case managers have intense connections to the individuals who are in the program and in recovery. I would say probably in the lifetime of the program we've had well over 150 participants.
I realize that question is perhaps antithetical. Like, I'm trying to boil what you're describing down to numbers and percentages. It probably doesn't have any place in this conversation. So thank you for your grace, and thank you for zooming out and working with people, because that's what we're talking about here, right? We're talking about people, not criminals, not offenders, members of our community.
And Kathleen, it's interesting you notice that, because that was something that Kylie brought to us. We used to call them, when the program first started, it was defendants. Then it moved to participants. But Kylie now has us talking about wellness relatives, and you heard Judge Decontie use that term in her discussion.
Yeah, we're actually anticipating our first non-Indigenous or relative to be joining us, which is very exciting. I know that I've always been taught you can't heal the left without healing the right. And if you're in a partnership and you're a part of this community, then you should have access as well. And that's what I talk about, the growth and expanding. And also, I had seen that folks that didn't make the tribal census not be able to access this program because you had to be a citizen of a tribe. So growing and expanding to descendants is, I see, going to be so much more beneficial, because we do have a lot of people that may not be on the census but reside here, have parents or grandparents that are enrolled members, and are essential and part of the community.
Go ahead.
I was just thinking, as Rhonda, Judge Decontie was talking about that, I wanted to make sure that everyone understood, when I talk about how we take individuals in from the state system, we've actually taken individuals where DHHS has said, we're going to take this child unless this individual enrolls in the Healing to Wellness program. In order to keep the 2 sovereigns separate, because they are separate sovereigns, we do a petition for admission into the wellness court. So an individual has to petition to come into the wellness court. Then there is an order of admission that is entered by the court. And that petition for admission is reviewed by the entire wellness team to say, okay, do we think this is a good fit? This is where we think ought to work. Some of the real benefits of that team have been, we had an individual who went through the program, and for us, you can go through this program as many times as you need to. They had gone through the program, and the first time in the program, they had essentially white knuckled it. They just went, I'm going to make this. And they did. And they commenced from the program. They did well for a short period of time, and then they started going back visiting places that they had been to in the past, people, places, and things. And they wanted to come back into the program. And I was like, well, of course they can come back in the program. And this was a real benefit to me for this wellness team. The doctor sits on the wellness team, and the behavioral health director sits on the wellness team. And they said, no, we shouldn't bring them back in. I'm like, what do you mean we shouldn't bring them back in? And they said, that individual white knuckled it. We should bring them back in if they will agree to go to inpatient treatment, because they didn't do that the last time. We recommended it. Now this is what they have to do. So that was what we set out as the condition for admission. The individual did do that, came back and said, that was the best thing I've ever done, was the inpatient treatment. But so that's a benefit of having that wellness team in that petition. So they have to petition, then we do an order of admission. That order of admission is what maintains the tribal sovereignty. Any sanction that is meted out because of a violation of a tribal order, not because of something that happened in the state, and we don't report back to the state other than they're in the program or they're not in the program. We've got questions. We'll see what we can do to answer them.
Thank you. I'm really glad that you're digging in and peeling back a little bit of the issue of sovereignty, because we've done a number of programs over the years in this space on legislation in the Maine legislature to acknowledge the inherent sovereignty of the Wabanaki nations. And over the last year or so, we've started to ask ourselves, with some really good helping from our friends, do you know what sovereignty means? Do you know what is different when the Maine legislature, the Maine state government, finally does acknowledge that? And this feels like a really powerful example of what it actually means in practice to have that inherent sovereignty recognized. And I'm curious, I know there was a bill just last year in the Maine legislature that had to do with tribal jurisdiction. Does that intersect with the Healing to Wellness Court at all, or not?
It does. So you're talking about the Tribal Law and Order Act bill. The Tribal Law and Order Act was passed in 2010 in the feds, and that's one of the anomalies of what has happened with the Maine Settlement Act. Because the Maine Settlement Act says nothing that the feds pass post 1980 that affects or preempts Maine law takes effect in Maine unless Maine agrees to it, or the feds say specifically that it can be that it's enacted in Maine. The two challenges that creates: one is financial. That is that there's always funding tied to those exercises of jurisdiction. And the tribes in Maine can't reach that level, can't reach that funding, because they're not able to exercise that jurisdiction. The second is that it delays the time that the tribal courts in Maine to gear up to exercise that jurisdiction. And that's just been a function of what's happened with the Settlement Act. I don't think there's ever been a federal law passed since 1980 that the state of Maine has not said, oh, it affects or preempts Maine law, and therefore we don't want the tribes to be able to exercise it. And that's a fundamental issue that is out there. The passage of TLOA this last year, or the state recognition of tribal law and order jurisdiction, means that the tribes in Maine can now exercise C felony jurisdiction, which is essentially most of the actions that we're going to see are C felonies. They're not going to be A or B felonies. That's murder, robbery. Those are, I can go on a whole discussion of the Major Crimes Act, but those are different things. So yes, the passage of the Tribal Law and Order Act, by expanding tribal sovereignty to C felonies, means that the tribes can reach out for some additional funding for their courts, for their law enforcement, for exercising the sovereignty on tribal lands.
not enough, but important progress. It really does seem like this multidisciplinary approach, housing, medical health, mental health, community connections. It's so unique, and that whole person approach, it probably shouldn't be unique. Are there learnings here that I like to think that the state of Maine is paying attention, that the federal government is paying attention, that others are attempting to create a similarly community-centered process. Is that happening?
It is actually, and particularly the federal government has been paying attention. Last year was the first year of the conference that we're doing the repeat of this next Tuesday and Wednesday. At that conference, that conference was initiated by the White House, the Department of Justice, and the Bureau of Indian Affairs. The three of them all said, "This is something we want to have you host." We had tribes from as far away as Alaska, California, throughout the United States come to that conference last year. It is, and Judge Decontie, her sister Donna Brown, myself have worked with tribes throughout the United States. We did Hopi, and I actually served as the Hopi Wellness Board judge, who I'd fly out there every other week to be their wellness judge for a short period of time. But we've helped Hopi establish their wellness board. We helped Lakoutere in northern Wisconsin. We work with a couple of different tribes. We're actually helping Southern Paiute shortly establish their wellness board. What the Penobscot Nation has done with that multidisciplinary team has been astounding, and the team deserves that credit because they are an incredible team. As you saw, one of the early slides in that talked about is the level of trust that's on that team, and the ability to say we can agree to disagree really is what makes the success of the wellness court. It really is that multidisciplinary braided services approach that based on trust that makes a difference.
Do you have plans or potential paths to extend the health and wellness court? I know one of the admission requirements is that you're diagnosed with substance use disorder, but it feels like this approach could apply to just about anything that has folks intersecting with the criminal justice system. What's next?
Judge Decontie.
I know you say that, and I'm like, well, we're really thinking mental health.
Yeah.
I think that's a project that, we need to start considering, and how do we build off of what we've created for, substance use, and kind of where do we go from here? But it's definitely on the top of our list.
The other one is an early intervention court, which will be led by Judge Decontie, which is an early intervention family court. What we've seen as a model is that in child protective matters, the social worker will go and go, look, here's a safety plan. These are the things that you need to do. And the parents are so relieved that when they leave, as I would be, quite frankly, when, oh God, thank God they've left, the safety plan gets put by the wayside. And so what we want to do is form that braided services approach when child protective services has been notified that their child may be at risk, that the problem can be resolved by a safety plan, by setting that safety plan up in the early intervention family court, and bring together that braided services approach, meet with the parents. We're still trying to figure out, still wrestling with how do we protect confidentiality in that situation, because a big part of the success of the wellness court has been bringing in the peers and having a peer-to-peer interaction. That has been a huge, huge factor in the success of the program.
Well, we'll have to make a date to have you both back to tell us about the next innovation and the next iteration. Thank you so much for sharing this incredible process with us today. Again, everyone will get a follow-up email with a whole bunch of information that we hope you will share and pore over, and hope to see you Tuesday and Wednesday at the conference. Next week, we will be look for, you'll also get an email this weekend with our lineup for October programs. Next week, October 4th, we will have Secretary of State Shenna Bellows here to talk with us about what to expect for the November elections. Can't wait to see you all there. Until then, have a beautiful weekend. And again, Judge Decontie, Judge Mehnert, thank you.
Thank you. Thank you all for having us.
Thank you so
Bye.
much.